Divorce in Florida costs a median $13,600, with most cases dragging on for up to a year. And child support, calculated by a strict formula in 2025, can transform your finances overnight. But what really determines how much you will pay or receive, and what traps could cost you and your children the most? A Florida divorce begins with two hard truths. You must meet the state's residency rule, and you will need to budget for the first round of costs. Filing is not automatic. Even if you are ready emotionally, the law requires that at least one spouse has lived in Florida for 6 months before submitting a petition. The filing fee alone ranges from $410 to $495, depending on your county. Add in required forms, and the process can feel overwhelming fast. Yet this first step is also a moment of control. The Florida Supreme Court provides official forms. No need to hunt the internet or pay for samples. Secure your personal documents now. Driver's license, proof of address, and if possible, a recent pay stub. Each piece of paperwork you gather now protects you from confusion or delay later. Filing is more than a legal ritual. It's the foundation for every financial and parenting decision that follows. Even if the road ahead looks uncertain, confirming you meet the state's eligibility and getting your documentation in order is a concrete, empowering first move. Florida law draws a firm line between what belongs to the marriage and what stays separate. Anything acquired during the marriage, homes, cars, retirement accounts, even frequent flyer miles, typically counts as marital property, no matter whose name is on the title. Gifts and inheritances kept apart, or assets owned before the marriage and never commingled, usually remain separate. Under Florida's equitable distribution principle, the court aims for a fair split, not always a perfect 50-50. Debts are divided the same way. A joint credit card or a loan signed by both spouses goes into the marital pot, regardless of who made the charges. Hidden cash jobs, business ledgers, or joint accounts with blurred deposits can trip up even the most careful planner. The first safeguard is simple but powerful. Start an evidence folder. Gather statements for every account, bank, retirement, investment, plus car titles, mortgage records, and proof of anything you brought into the marriage. Even a handwritten list, dated and signed, can help if documents are hard to find. These early steps protect your claim before the stress of negotiations begins. Florida Statute Section 61.075 guides every judge's decision, but your own records are the strongest shield against confusion and loss. Florida recognizes several types of alimony, each designed for a different life circumstance. Bridge the Gap alimony, capped at 2 years, helps with short-term needs as you move from married life to independence. Rehabilitative alimony supports retraining or education, with a clear plan and time limit. Durational alimony fits marriages that do not qualify for permanent support, ending after a set period. Permanent alimony is now rare, reserved for long-term marriages, and only when no other option meets basic needs. Judges look closely at the length of the marriage, your financial resources, and the sacrifices made, especially years spent as a caregiver or out of the workforce. Documenting career breaks, lost earning potential, or time spent raising children is essential. Evidence can include resumes, letters from employers, pay stubs showing gaps, or even a calendar of caregiving years. The law requires a detailed financial affidavit, and if you seek rehabilitative alimony, a written plan for returning to work. Every claim must be supported by clear records. Even if the process feels exposing, these documents turn your caregiving and household work into recognized value under Florida Statute Section 61.08. An experienced attorney can help translate your life story into the language of the court, making sure your contributions are seen and counted. Florida courts begin with a simple premise. Both parents should remain actively involved in their child's life. The law presumes shared parental responsibility, which means major decisions, school, health, activities, are made together unless there's clear evidence this would harm the child. Sole responsibility is rare and requires proof of serious risk, like documented abuse or ongoing danger. Every divorce involving children requires a detailed parenting plan, and the court won't finalize your case without one. The official Florida template asks you to spell out how time will be shared, where exchanges happen, how holidays and vacations are divided, and how you'll communicate about your child's needs. It also covers who can access school and medical records, how address changes are shared, and what steps you'll take if you disagree. Leaving blanks or writing TBD can delay your decree. Judges reject vague or incomplete plans. Using the most current court-approved form protects your child's routine and helps avoid confusion later. Even if you and your co-parent don't agree on everything, a thorough, child-focused plan gives your child stability and keeps day-to-day life predictable, no matter how the adult relationship changes. Calculating child support in Florida starts with the income shares model. Both parents' net monthly incomes are added together, then matched against the state's guideline chart to find the base obligation for the number of children. For example, if the combined net income is $6,000, the guideline for 2 children is $1,638 per month. If the total exceeds $10,000, the law adds a percentage for each extra dollar, 7.5% for 2 children. So a combined income of $12,000 means the obligation rises to $2,378. Each parent's share is set by dividing their net income by the total and multiplying by the guideline amount. Add-ons like health insurance, daycare, and uncovered medical expenses are split in the same proportion. When time-sharing crosses 73 overnights per year for both parents, the worksheet applies a separate adjustment to reflect shared care. If payments stop, Florida offers a robust enforcement toolkit: wage garnishment, driver's license suspension, tax refund intercepts, and even contempt of court. The Department of Revenue can step in to collect, and missed payments are not forgiven. Keeping pay stubs, tax returns, and receipts organized makes the math and the enforcement work in your favor. As one CPA explains, accuracy and documentation are your strongest allies in every calculation and dispute. Choosing between mediation and court shapes both the financial and emotional path of a Florida divorce. Mediation usually costs between $600 and $3,600 for straightforward cases, with fees ranging from $150 to $450 per hour, and most families complete the process in 2 to 4 sessions. In the Orlando area, rates often fall between $250 and $400 per hour, but many mediators offer payment plans or sliding scales for those with limited income. By contrast, litigating a divorce in court can cost $15,000 to $30,000 per spouse, sometimes much more if the case involves complex assets or a custody fight. Court cases may stretch over a year, while mediation often wraps up within a few months. Mediation gives you flexibility in scheduling, more privacy, and a chance to shape your own agreement. For some, though, court is necessary, especially if there's a history of intimidation, hidden finances, or safety concerns. The first step is to book consultations with both a certified mediator and a family law attorney. Comparing their advice helps you make a choice that fits your needs and protects your peace of mind. 12 months of pay stubs and 2 years of tax returns form the backbone of any Florida divorce file. Courts expect detailed records, not just for salary, but for every source of income, from side jobs to rental checks. For self-employed women, business ledgers and bank statements carry extra weight. Organizing these documents early means fewer surprises if income is questioned or imputed. Once paperwork is secured, the next task is rebuilding financial stability. Credit scores often dip during divorce, but steady payments and reduced balances can restore them within 9 to 14 months. Start by tracking every expense for a week, then set up a basic budget. No fancy apps needed, just a list and a calculator. Even a simple emergency fund, built $5 at a time, creates breathing room. Therapists recommend a daily 10-minute routine, gentle stretching, mindful breathing, and jotting down one thing that went right. This small act of self-care can make the difference between feeling overwhelmed and finding a sense of control. Each habit, each document is a step toward recovery, both financially and emotionally. In Florida, the median cost of divorce now stands at $13,600, and the statutory income shares model determines child support based on both parents' incomes, as outlined in Florida Statute Section 61.30. We've seen how the law sets clear guidelines for support, with a $10,000 income threshold and mandatory add-ons for healthcare and childcare, but leaves room for case-by-case adjustments. Despite detailed statutes and worksheets, some questions remain, such as how courts weigh non-monetary contributions or future changes in parental income. The evidence shows that mediation often costs less than half of litigation, and that organized documentation is critical to ensuring fair outcomes. As of 2025, Florida's alimony rules and child support enforcement tools have become more precise, but the process can still feel overwhelming. The facts are clear. Understanding your rights, gathering evidence, and using official state resources are the surest ways to protect yourself and your children. This is educational information, not legal advice. Laws vary by state.